All right, let us get started with the third and the final part of professional standards. This is a review of the class that we had on Wednesday, March 15, 2023. This is a review of the class that we had on March 15, 2023. Let's get started. The third prong of professional standards that we're going to cover takes us to the Carbone v. Tierney case. Let's do a quick recap. Our first case was, do we measure professionals by a layperson standard or by a reasonable professional standard? So let me say that again. The first case that we did was the case involving Osborne versus Irwin Memorial Blood Bank. And the question in that case was, when it comes to professional negligence, do we measure the standard of care, right, in order to determine if that standard has been breached? The way that we measure that standard of care is by measuring the standard of care provided by the defendant attorney, measured that by the standard of care that is offered by other professionals, reasonable, similarly situated, who are using their customs and their practices. Okay. Real quick recap of Osborne. That was the 3-week-old baby, had to have open heart surgery, received blood from a blood bank, received the AIDS virus as a result of that transfusion of blood. Parents of the child sued. Lots of things were alleged. Finally got down to one defendant, 2 allegations, negligence and negligent misrepresentation. As to the negligence, in professional negligence cases, you have to establish the same that has to be established in general negligence cases, which is standard of care, breach of standards, well, a duty, which is the duty of care, the breach of that duty, causation, that's actual and legal, and then damages, right? Osborne helped us understand that when it comes to professional negligence, while the reasonable person is the standard for general negligence, it's the reasonable professional that is similarly situated that uses the customs and the practices of the profession. That's the measure, okay? Period. Stop right there. Then we go to the second prong of professional standards that we covered, and that is the Russo case, right? That is just a real quick recap. That's Russo v. Griffin. In that case, we have a client who is suing an attorney for malpractice, and we know that we must have professional standards, right? We learned that from the Osborne case. In Russo, we have the professional standards that are submitted to the court through evidence of expert witnesses. We have the expert witness for the client, who's the plaintiff, who says that the measure of the standard of care is statewide. We have the experts for the defendant, that's the defendant attorney, who says the measure of the standard should be based upon local customs and practices within that locality. That is AKA the locality rule. And the rule that we walk away with, the rule of law that we walk away with from Ruffin is, in a situation, legal malpractice, trying to establish what the standard of care is, if it is between a locality rule, which looks at the customs and practices of attorneys in a smaller location, right? Smaller geographic location, versus the standard of care, the customs and the practices of attorneys that are similarly situated within the state. The choice is going to be the statewide standard of care. That now brings us to the Carbone v. Tierney, third prong of professional standards. And this is as much as we are going to cover in this torts 2 semester. We talked about it to a great length on Monday, helped us bring in the important issue of mental health, the importance of protecting your mental health, the importance of not believing the lie that is, if you need some support, then somehow you are less worthy, you are less capable, you are less competent, you are less valuable, because all that's nonsense. Okay. Every bit of that is nonsense. But because we're not going to focus the rest of this video on mental health, we'll move on, but it was just important to say it again. Finally, within the last 20 years, the legal profession as a profession has embraced and accepted the reality that all of the work that we do as lawyers involves our ability to think in those processes. And that, no matter how amazingly intelligent or brilliant you are, becomes overworked at some point. And that causes some damage to you. If you are aware, if you are living a well-balanced life, if you don't allow the passion of justice overtake you, you will probably make some steps to protect yourself. If you are an all-in, go get them, I'm giving it 110% all the time because I have the disease of perfectionism, be mindful. Just be mindful to give yourself grace, to take care, and to be kind to yourself. Go back to Carbone. Why is this such a big deal? Because Carbone is a case of an attorney who was overwhelmed for whatever reason. She was overwhelmed, and we're not to judge the reason because we don't know the reason. But by all stretches of the imagination, she was overwhelmed. The attorney who is the defendant in this case, last name is Tierney. The client who is the plaintiff in this case, last name is Carbone. You have the Carbone v. Tierney case. Real quick recap of the facts. Carbone hired attorney Tierney to file a federal suit in federal court in New Hampshire. Attorney Tierney filed the suit, failed to allege the subject matter jurisdiction. The suit got dismissed. Attorney Tierney refiled the suit, not understanding that before she could refile the suit, she had to appeal the dismissal of the first suit. When she refiled the second suit, it was automatically dismissed because she hadn't appealed the first. She then files the federal claim in the District of Massachusetts, I believe, but Massachusetts failed to have personal jurisdiction, so the case was dismissed. Attorney Tierney then filed a state version of the suit in the state court in New Hampshire, and to know inadequacy or deficiency on her own. It had something to do with the court system itself. The suit got dismissed. Attorney Tierney failed to follow up to find out why the suit got dismissed. Ultimately, client Carbone says, if you will represent me as an attorney for a creditor. And if you will object to the homestead exemption that my son and daughter-in-law are going to claim, we might be able to put the rest of this under a rock somewhere and just move on. Attorney Tierney accepted that responsibility. It appears that she would have filed the claim as a creditor in the debtor case of bankruptcy. She failed, however, to meet the first meeting of creditors, which means the claim was then denied. And we now have Carbone, the client, suing the attorney for malpractice. There's 3 issues in Carbone. There's an issue of whether or not there needs to be expert testimony to establish proximate causation by connecting the actions or the lack of action of the attorney to the harm that is alleged to be suffered. There's the issue of collectability of the judgment. So in other words, if the attorney did what they should have done or didn't do what they should not have done, and if that led to a judgment for the client, if that judgment would have been judgment proof, meaning it's a judgment that's reduced to writing in an order, but there's nothing that can be collected upon to satisfy that judgment. Basically, it's just a judgment on a piece of paper. The question is, should then the collectability of the judgment or the lack of collectability of the judgment be considered in the judgment of damages against the attorney in the malpractice suit? The third issue is if the judgment that is rendered on behalf of the client against the defendant attorney in the malpractice suit, if that judgment, if there is a judgment, should be reduced by the amount of the contingency fee that the attorney would have received from the client had the attorney done the work that the attorney was hired to do. 3 issues, 3 rules. Rule number 1, when it comes to malpractice and establishing legal malpractice against an attorney, expert testimony is required in order to create the causal connection between the acts or omissions of the attorney and the alleged harm of the client. Gotta have expert testimony. The reason that you have to have expert testimony is because the trier of fact has to establish a couple of things. Number 1, the trier of fact has to establish that there's a connection, right? There's a connection in the attorney's failure to do or failure to do accurately or failure to meet the standard. There's got to be a connection between that and the actual harm suffered. Remember, negligence, causation, you've got actual cause and legal cause. This is the legal cause. That legal cause is especially important in legal malpractice cases because what the trier of fact must be able to determine is if the attorney did what the attorney should have done, like the attorney should have done it, would the result for the client be different? Would the result for the client be better? In other words, would the client have actually won? And we got to have an expert to give us that information so that we can make that calculated call. Because if there's no harm, which means if the attorney had done what the most brilliant, most effective, most wonderful, most great, most intelligent, most powerful attorney did, had the attorney met the standard, if the outcome for the client would have still been a loss, then this case is moot. Okay, so Rule number one, you must have expert testimony as it relates to the proximate cause so that it is clear that the acts or omissions of the defendant attorney is actually the legal cause. Got it? Rule number two, collectability. Because collectability is not a specific element, right? The elements are duty, breach of duty, causation, damages. Collectability is not a specific element of legal malpractice. And as a result, collectability may then be urged as an affirmative defense by the defendant attorney. Doesn't have to be brought up by the complaining client. It has to be alleged by the defendant attorney. It's alleged as an affirmative defense. So it has to be pled and it has to be proven by the defendant attorney. Rule number three, no. The verdict or the judgment that is received by the complaining plaintiff, that's the client, will not be reduced by the contingency fee of what the attorney would have gotten paid had they been successful. The answer is just no. If you get the judgment, that's the judgment. It's not going to be reduced by what the client could have paid, should have paid, would have paid. The judgment's going to stand as the judgment is. That's Carbone. If you have any questions, read it again. If you have any questions, read it again. If you have any questions, if you made it to class on Wednesday, look at your notes. If you still have questions, listen to the first 18 minutes of this video again. If you still have questions, reach out to one of my two marvelous teaching assistants. And if you still have questions, please, please, I urge you, I beg you, I motivate you, I encourage you. Reach out to me. Reach out to me. I want you to build the muscle that results from the struggle of the challenge, right? I want you to struggle. I want you to try to fix it out. I want you to lean in and accept the challenge that it might be difficult. It might not make sense. You might have to read it 10 times. That's what lawyers do. But when it gets to the point that you've given it all that you can, and you can't figure it out, and now you're just in this world of chaos, reach out. There's a difference between wrestling with the challenge and being lost in the chaos. None of us, no professor wants you to be lost in the chaos, right? No, none of us do. But I feel comfortable saying that the majority of us, however, want you to lean into the struggle, build the muscle, learn how to figure it out. That's what your license requires you to do. That's what your future employers, your clients are future employers, your partners are future employers, the people that you work for are future employers. That is what your future employers are relying on you to do. We're going to end professional standards. Those are the three that we've done in a nutshell. That's that. Let's move on to occupiers and owners of land. Occupiers and owners of land. We are now in chapter 10 of the textbook. All of these fall under the general category of premise liability. What is premise liability? What is premise liability? That's a really good question, right? What is it? What liability does a landowner owe to another who enters their land? You own a piece of property. You have a gate around it. You have a fence around it. You have a no trespassing sign all over it. And somebody comes upon your land anyway. They get through the gate, they get through the fence, they find ways to step through all of the no trespassing signs. Duty of care do you owe to that person? This is the reason roll their eyes when you say lawyer. And I laugh because it's understandable, right? It's understandable. Many of our answers began with, it depends. It depends, right? The majority of what we do as licensed attorneys, right? We've got a rule of law, and which way we go as a result of that rule of law is fact, F-A-C-T, fact dependent, right? So what liability does a landowner owe to another who enters upon their land? It depends on the status of the person who enters upon the land. It depends on the status of the person who enters upon the land. There's three status that we're going to cover. The status as a trespasser, the status as a licensee, and the status as a invitee. Trespasser, licensee, invitee. What's a licensee? Licensee is defined as someone who has been granted limited rights, either expressed or implied, to enter upon or be upon the land of another. This person has limited rights to come upon your land, but it is of no commercial benefit to the owner. No commercial benefit to the owner. So then what's the benefit? An example of a licensee is a visitor, right? You invite them, don't get confused. We're not talking about invitees, we're talking about licensees. And you invite them on and you give them a quote unquote license to have a good time. Get it? I'm trying to work with it, trying to build some relative connections for you. Social guests who are given the license to come and party, right? That's a licensee. So what is the duty that the landowner owes to the person who is asked to come and hang out with me? Let's come and have some M-O-C-K. Let's have some mocktails. Let's hang out by the pool. Let's, come over, we'll study together. What duty does the landowner owe to a licensee? They have the duty to ensure that the conditions upon the land that is being entered is safe. A duty to ensure that the property is safe. They have a duty also to warn of known dangers, but they do not have a duty to inspect to try to find dangers. Got it? Duty to ensure that the conditions of the property are safe. Duty to warn the licensee of known dangers. Hey, when you're in the pool, don't jump off of that diving board because that one's broken, right? A duty to warn of known dangers, but there is no duty to expect for hidden dangers. Perfect. What about an invitee? An invitee is a person who enters another's property for commercial or professional reasons. An invitee is a person who enters another's property for commercial or professional reasons. This entry is for the commercial benefit of the property owner. What's an example? Customers. Customers are invited. So customers are invitees because the owner wants you to come into the store and spend your money, right? Invitee, money, right? You get it? Patients are invitees because the doctors want you to come into the office so that you can pay your copay so they can get money, right? You're paying for services, right? So an invitee is a person who is encouraged to come upon your property, but you're coming upon the property for the financial, for the commercial benefit of the property owner. Grocery stores, you're an invitee. Get it? Come on in here, get your greens, and spend your money. My rapping skills. I know I blew everybody's mind in class yesterday when I was dropping those bars. I was dropping them. They were hot. They were hot. Okay. What is the duty of an owner to an invitee? That of the three status, licensee, invitee, trespassers, the duty that the owner of the property has to the invitee is the highest of them all. And that makes sense, right? If I'm inviting you onto my property so that you can spend your money, or because it's going to benefit me commercially or financially, it only makes sense that I have a duty to not only keep the premises reasonably safe, keep the premises in a safe condition, let you know about the known dangers, but it would make sense that I would have to also inspect and find unknown dangers, right? Because I wouldn't want you to come into my grocery store and then there's a hole in the floor that we've covered up with paper towel, and then you fall through the hole in the floor, right? That is inconsistent with a successful business plan for my business. Yeah. All right. So the invitee, the duty of the owner is the highest to the invitee. Trespassers. Well, this one's easy. A trespasser is defined as someone who enters land or property. Right? You see no trespass signs all the time. And we understand as a social rule, especially if we have a no trespass sign, that we don't want people on the property that we have not asked to come over as social guests, right? Licensees, or that we have asked to come over for commercial invitees. If you're not part of the family, and maybe even sometimes part of the family might be trespassers, so that's a bad example. But if you're not an invitee or a licensee, I don't want you on my property. And if I don't want you on my property because you have no right to be on my property, then what duty as a landowner should I owe you? I didn't ask you to come. I didn't advertise for you to come. I surely didn't send you an invitation to come. Then why would I have a duty to keep you safe when you shouldn't be here in the first place? Well, check it out. Landowners are liable to trespassers, which means landowners have a duty, as far as trespassers are concerned, to not commit intentional torts against them, right? Well, that's a legal duty because you're not supposed to be committing intentional torts against anybody, right? So that fits. Landowners have a duty to not act against the trespasser recklessly or willfully or wantonly, right? That's that gross negligence, right? But as far as general negligence is concerned, no duty. No duty. You're not supposed to be here. So I can't commit an intentional tort against you, and I can't act grossly negligent against you. But as far as general negligence is concerned, I don't have a duty. I don't see you. It means nothing to me, right? However, this is the time when Ms. Jimenez jumped up and said, hold on, hold on. Ms. Jimenez and Ms. Lewis were on fire yesterday. Ms. Jimenez said, hold on. What about attractive nuisance? Boom. And I said, what a perfect segue. Not only perfect segue into the attractive nuisance doctrine, but a perfect segue into the Hill v. National Grid case. Hill v. National Grid, right? Went through the procedural history, went on to the key facts, had Ms. Clark, called on Ms. Crockett, called on Mr. Eady, called on Edwards, and said, what are the key facts? The key facts are as follows. I got a group of tweens, I guess that's tweens, right? Teenagers, but not kind of like teenagers, right? Group of 12-year-olds, probably 11, 12, 13, on the vacant lot of National Grid. You see, I made a mistake there, right? That says National Guard. I'll have to fix that. National Grid is a public utility company, and they had some vacant lots. And the kids were trespassers, right? They weren't asked to come onto that property. They're not over there buying ice cream or cookies or, snowballs on the property, right? So they're trespassers. But it seemed from the facts that this was a vacant lot, seems like the lot was pretty flat and seems like the lot was pretty big. And so from time to time, it seemed that this was probably a pretty regular gathering place for these youngsters to get together and have an impromptu game of touch football or whatever it was they were playing, right? On this particular day, and I love how the case starts because it says on this beautiful fall day or something like that. You got the kids out there playing, and this one kid, I guess, catches the ball and he trips. But he trips on a metal pipe that's sticking out of the ground, right? And he trips. Well, kids trip, kids fall is part of the game. We're 12, right? We haven't figured out how to stop having fun. Right. So it's no big deal. You trip, you fall, you get up, you laugh, you move on. The problem was when the child fell, he fell on another metal pipe that slashed his thigh. Right. And so now you got blood gushing. I said in class, probably hit that femoral artery, right? It hits something large enough that it's gushing, right? And what's so beautiful about being 12 is life's just not complicated yet. We, as children, we are so ready to be adults because there's a peace and a protection about being a child, right? Because this kid is like, oh, got blood gushing from my leg. I should probably go home now. And he jumps on his bike, and it's not funny, but it's actually kind of beautiful, right? He jumps on his bike and he goes home. Imagine if I fell on something and gushed my leg and there's blood after I pass out fourth and fifth time, hopefully somebody's called 911. Anyway, kid goes home. Mom takes kid to the doctor. They get it all stitched up. Kid winds up having a scar, but most kids, or it used to be, most kids would grow up with scars, and those were the good stories because I got that scar or I got that scar. But anyway, kids got a scar, no big deal. Sue on behalf of the child because the child's a minor. Mom and dad sue the public utility company National Grid and said that they were negligent in the upkeep of the property. National Grid comes back and says, your kid and all the rest of these little children running around are trespassers. We owe no duty to you as trespassers. As we have seen in many of the cases that we've reviewed this semester, the parents had filed a summary judgment motion saying, here's the affidavits, here's what it is. There's no issue. There's no material issue. There's no genuine issue of material fact because none of this stuff can be disputed. This is their property. Yes, my kid was trespassing, but it's an attractive nuisance. So the owner of the property should have known that this was going to look attractive to the kids. The kids were going to come and the kids were going to play. And as a result, because of that attractive nuisance, there's a duty owed to my trespassing child. Yeah. In their affidavits, National Grid, their affidavit said, yeah, I didn't know about these pipes. There's no way for me to have known about these pipes. You want me to be a mind reader, and that goes beyond the duty that I should have to have, right? Trial court agreed with National Grid and denied the motion for summary judgment. The parents appealed, and the appeals court agrees with the parents. Here we go. This question was going to be, what is the issue? But before I ask, what is the issue? I put this image here. Many of you might not understand the reference. It was a sci-fi show. Sci-fi was big back in the 60s, 50s, 60s, 70s. One of the shows was called Lost in Space. When this show originally aired, it was in black and white. I know some of you are saying black and white, what? I mean, right? There was a time in this life where the TV death, they were not 4K, they were black and white TVs. And when this show, Lost in Space, originally aired, it was in black and white. And anyway, the young man had befriended a robot, and the robot had made it his responsibility to take care of this kid. And so if there was danger around, the robot would scream, "Danger, Will Robinson, danger, Will Robinson." And when it comes to the issue, I wanted to express, this is where we've got to slow down, because this happened a couple of times. Slow down. If you are reading from the book or from Lexis, and if you read this case superficially, you are going to see in the opinion where the court says, the appeals court, the reviewing court says, that the issue in this case is whether or not the lower court erred when it failed to grant the summary judgment motion that was presented by the parents, right? That's what it says. You can cut and paste it, you can quote it, you can cite it. That's exactly what it says. But again, if you look at our syllabus, where are we? Are we in the world of summary judgments? No, of course not. That is a civil procedure technique that we've seen a lot in our cases, but you haven't even taken civil procedure yet. You haven't even taken it. The concept has not been formally introduced to you. The concepts of MSJs, right? We've had to do with MSJs, motion for summary judgment. We've had to deal with Allen charges. We've had to deal with JNOVs, judgment notwithstanding. We've had to deal a lot with procedural issues. And I've tried to highlight them as a soft introduction, but that's why you're going to take civil procedure, so that you can become more familiar with the process. But for our purposes, the syllabus says that we are talking about what? We are talking about the duty a landowner owes to licensees, invitees, and trespassers. So what does that mean? That means that in order to get to the issue of should the summary judgment motion be granted or not, we've got to deal with this issue of attractive nuisance. What does that mean as far as trespassers are concerned? And what does that mean as far as the duty that a landowner might owe to a trespasser? We've got to address anywhere. Understanding that, what's the usual law when it comes to landowners? What's the usual law when it comes to the duty that a landowner owes to a trespasser? Usual duty is there isn't any. Got it. As to a trespasser, the landowner has the duty to not commit an intentional tort and to not address the trespasser with gross negligence. But that's it, except for the attractive nuisance doctrine. The attractive nuisance doctrine, right? Then I go on and I ask students, well, what is the attractive nuisance doctrine? What do you have to show to urge a successful, yeah, I was trespassing, however, because of the attractive nuisance doctrine, you property owner may still have some liability. Here it is. Restatement of Torts 339 is the second restatement of torts, 339. Attractive nuisance. A landowner owes a duty of reasonable care. Wait, what? I thought I had a duty not to commit an intentional tort, and I thought I had a duty not to commit gross negligence. But now you're saying this whole general negligence comes into play because now I have a duty of reasonable care. Yes, you do. A duty of reasonable care to children. All right. So what do I have to show? This is it. One, that there is an artificial condition that's inherently dangerous. Now, inherently dangerous is actually not in the text of the rule, but it's got to be something that's inherently dangerous, right? An artificial condition might be, I put a, yeah, I'm having a hard time thinking about one, right? But an artificial condition exists on the landowner's property. Hold on, I'm not done. And the landowner knows or should have known about the existence of that potentially dangerous artificial condition. Hold on, don't ask questions yet. Let's get through all of the pieces. This is a conjunctive rule, which means all of these things have to be satisfied. So let's just go through them. Second thing that must be established is that the landowner knows or should know the land that holds the dangerous artificial condition is a place where children are likely to trespass. Number three, children, because of their youth, do not discover the condition or do not realize, or here's another term of art, do not appreciate the risk involved. Number four, the utility to the landowner of maintaining the condition and the burden of eliminating the danger are slight. What does that mean? For the landowner to keep the condition as it is versus the landowner eliminating the danger, it's slight, right? That's just slight. That it means it's nothing compared to the risk of protecting children, because protecting children trumps just about everything, as it should. They're children, right? And number 5, the landowner fails to exercise reasonable care to eliminate the damage or otherwise protect the children. If you can establish all 5 of these prongs, then you've established attractive nuisance. I'm at 45 minutes on the video, which tells you that we ran out of time, right? We ended class yesterday, but we didn't really end class smoothly, because this next part, I think, is critical. This next part, I think, is critical. Let's take these 5 prongs and let's analyze them as it relates to the National Grid case. Let's take these 5 prongs and let's analyze them, right? Because what we know is identifying the issue is not the most difficult thing to do, right? Sometimes we get the wrong issue because all of these cases have lots of different issues, right? But usually you've got a pretty good probability, you've got a good probability of success when it comes to identifying the issue. Okay. When it comes to the rule, sometimes you remember the rule, sometimes you don't remember the rule, sometimes you can piece the rule together. So while the rule some challenges, you still have a pretty decent probability of getting that right. When it comes to the analysis, you see I'm doing an IRAC, or you can call it a CRAC, right? It's the same thing, just different, right? Conclusion, rule, application, or analysis, right? When it comes to that A and the IRAC or the CRPAC or the CRAC, right? Or the CRAC, when it comes to that A section, this is where most of us miss our points. And this is why we miss it. We know what we're trying to say. We've already oftentimes built a conclusion in our mind, and we're just trying to get to the finishing of the conclusion. Instead, we need to develop a process that we execute each and every time we have the opportunity, so that we can build muscle memory for the process. So no matter how many prongs I have to establish, if it's 1, if it's 5, if it's 10, I have a process so that I don't leave any points on the table. Here's a process. Let's go to the first thing that we have to establish. We have to establish that an artificial condition exists on the landowner's property and the landowner knows or should have known. Go to the Hill v. National Grid case. What facts do I have to support or negate this prong? The facts that I have to support or negate, actually, it's not a negate, to support this case or support this prong is the artificial condition. What's the artificial condition? The metal pipes. Why is that an artificial condition? Because it's not natural for metal pipes just to grow out of the ground. Not yet. Not saying that sometime in the future that won't be natural, but as of right now, it's not natural, right? So we have an artificial condition that exists on the property. Gotta finish the rest. Gotta finish the rest of the prong. I don't get to go to the second prong. I'm not done yet. Now that we've established that we have an artificial condition that exists on the property, those are the metal pipes, we have to establish that the landowner knows or should have known about the existence of these pipes. How do I do that? Go to the facts, go to the facts, go to the facts. What are the facts that support that the landowner knew or should have known? We have the testimony of the employee who's responsible, I guess, for maintaining the property, who says that he's been out there, 5 or 6 times over the last couple of years, right? Okay, well, he's an agent of the employer. How do we know that? Because he's an employee of the employer. How do we know that? Because he told us. What is the scope of his job? The scope of the employee's job is to go out there and check out the premises, right? Part of the scope of his job includes making sure that the grass is cut. Part of the scope of his job is to walk the property. While the landowner might say, I don't know anything about it, and I wouldn't have any reason to know about it. Why should I know about it? The landowner should know about it because his agent knows about it. So I've taken facts specifically, directly quoting from my hypothetical that support my prong number one. Do I feel like I'm moving slow? Yeah, you do. Of course you do, right? But you got to take time to execute the analysis. For all of us who read fast, for all of us who think fast, for all of us who come from our undergraduate years and we were the first one done, we read fastest, we were the first one to turn our test in, we were always out of the test. Slow the heck down, or you're going to miss it. You're going to miss it, right? I now go to number two prong. Knows or should know that the land holds knows or should know the land that holds the dangerous artificial condition is a place where children are likely to trespass. It doesn't take a genius to figure out that with a little bit of land, especially if it's a little bit flat, and if kids are in close proximity, those kids are going to find out something to do with that property. Once, remember the good times, right? I want to have an impromptu game of soccer or football. For many of us who lived in the city, you use the street, right? But for some of us who live more rural, or for some of us who live, further out, you're looking at some vacant lots, or you're looking at some vacant land, or you're right. Sometimes it's a parking lot. So should the owner have known that it's likely that the kids are going to trespass? Sure. And another reason why, let's go to the facts. Always, always, always don't rely on your personal experiences. Always, always, always in a legal analysis, go to the facts. The facts say, again, we've got an employee who goes out there. And if we've got an employee who goes out there, any of you who have kids, any of you who look at kids, any of you who know anything about kids, brothers, sisters, cousins, nieces, nephews, if you've got a group of kids visiting a place regularly enough, it's not going to be hard to tell that some kids have been here. Okay. So he's got his employee out there who's walking the premises. Employer, as the owner, knew or should have known. The children, because of their age, do not discover the condition or do not realize the risk. The age of this kid was 12. Now, if you read the full case, you might get a better understanding that there was more at play for this 12-year-old than that he was just 12, right? But you might not, because you might not get the full transcript where we describe, well, tell me what this 12-year-old does, and tell me what are the things that they like to do, and tell me where do they spend their time, right? But there's information that would support that he's a 12-year-old. He's a child, yeah. And if there's nothing else in the facts, you pull the fact that he's 12, you pull the fact that he has a bike, you pull the fact that he's out there with friends, playing football, more likely than not, this is going to support that he's a kid. And because the law treats them as incompetence, right? And I don't mean that in the worst of the worst of the worst of the way, but children are not expected to have the judgment or the bandwidth to have the judgment to make logical calls. That's why we have so many laws that protect our children. Okay, so number 3. Number 4, the utility to the landowner of maintaining the condition and the burdening of eliminating the danger are slight as compared. We don't really have any facts that talk about what he had to do to maintain the metal pipes. We don't have any facts that talk about that it would have been a slight financial burden or a slight financial investment to remove them. We don't have any facts to rely on, but you can argue all day long that children's health and safety are paramount. And whatever utility, couldn't have been much utility in these metal pipes because the owner said he didn't even know they were there. So the fact that the owner testified that he didn't even know that they were there that's a fact that you can pull from the fact pattern to argue there's no utility because the landowner didn't even know they were there. So if you compare that the landowner didn't even know that they were there to the risk of the kid is going to outweigh it, right? The risk of safety, right, is going to outweigh it. And then last one, number 5, the landowner fails to exercise reasonable care to eliminate. And what do we have from the fact pattern? We know that the landowner failed to eliminate the danger because the doggone kid tripped over a metal pipe and then slashed his leg on a metal pipe, right? Now, my analysis is complete. Get it? I had to pull facts, specific, word by word, from the record, from the case itself, to support each of those 5 prongs because it's a conjunctive rule. What do I mean by it's a conjunctive rule? You've got a number 1, you got a number 2, you got a number 3, you got a number 4, and check this out. You've got an and. So what that means is all of these things are required. It is a conjunctive rule. I have to satisfy all of them. So I have to have facts that support each of the prongs. That's when my analysis is over. I can then go to my conclusion and say, because 1 and 2 and 3 and 4 and 5 are satisfied by the facts that are provided in the hypothetical, therefore, I would say that the attractive nuisance doctrine applies. And because the attractive nuisance doctrine applies, the landowner owed this kid a duty of reasonable care, and he breached it. He violated it. Get it? You got to slow down. You got to take it step by step. Right. And I will leave to your legal writing professors and your appellate litigation professors and all of those people who have gifts and talents in teaching those skills to talk to you further about the different ways that you can see rules, because you've got a conjunctive rule, you got a disjunctive rule, which means it's an or, right? Or you've got a balancing test, or right. There's lots of different ways that rules can appear. Again, you have amazing professors who are going to walk you through that, navigate you through that, help you build that skill. But that's why I keep harping on, if it's an and, that means it's a conjunctive rule, which means you have to all of the pieces. Yeah? All right. Woo! Attractive nuisance. I was going to ask again, what is the attractive nuisance doctrine? Don't need to do that. I was going to ask, what is the holding? The holding was the motion for summary judgment, hold on. Oh, that's right. I got it wrong in the beginning. Summary judgment was granted on behalf of the grid. I apologize. I got it wrong in the beginning. The summary judgment motion was filed by the defendant because the defendant was like, I don't know anything about this. I don't know anything about this. I don't know anything about this. You can't prove that I know anything about this. So the trial court granted the summary judgment. What the appeals court did was they vacated that summary judgment and then they remanded the case back for trial. So that's where we are. That's where this ends. Took us an hour to get through that, just doing it as a video that I'm going to post. So again, we were able to complete it on Wednesday, but we went through it so quickly. I wouldn't have understood it if that was the first time that I had walked through it. And so I thought it was in everybody's best interest to slow it all down, take our time, let's go through it. I'll post the video, and then that way you can look at it, you can reason with it, you can wrestle with it, you can rewind it, you can do all of those different things. However you need to do it so that you have within your power the ability to master it, right? You now have the information, you have the case from the book, you have the ability to pull the full case from Lexis if you think something's missing, you have the ability to pull it from justia.com, you have the ability to pull it from Westlaw, right? Don't let there be gaps. If something doesn't make sense to you, wrestle with it. That's what we as lawyers do. That is what we are expected. That is our rightful service and our responsibility. That's it. We are now done with professional standards, and we've already started with the duty that the landowners owe to the different status of people who might come upon their land. We've addressed the issue of attractive nuisance, and what we're going to address tomorrow, which is Friday, is going to be tenants and their guests. Yeah, amazing, great job. If you have any questions, reread the case. If you still have questions, read the case again. If you still have questions, look at your notes. If you still have questions, use the video. If you still have questions, we have two of the most phenomenal teaching assistants. Listen to the teaching assistants. If it's not enough, I am here, and this is the reason that I'm here. You have 24-hour days, 7-day-a-week access to me, right? You call me at 3 o'clock in the morning, I'm probably not going to answer the phone because my phone is on do not disturb, but you know that you can shoot me an email, you know that you can shoot me a text, and you know probably about 4:30, I'm not going to call you back, but I will be in touch shortly. It's my pleasure, it's my honor, and I will see you on the other side.